spark antitrust suit against Apple. The Attorney General is speaking now. Let's listen.
Violating Section 2 of the Sherman Antitrust Act. Over the last 2 decades, Apple has become one of the most valuable public companies in the world. Today, its net income exceeds the individual gross domestic product of more than 100 countries. That is in large part due to the success of the iPhone, Apple's signature smartphone product. For over a decade, iPhone sales have made up a majority of Apple's annual revenue. Today, Apple's share of the U.S. performance smartphone market exceeds 70%, and its share of the entire U.S. smartphone market exceeds 65%. Apple charges as much as nearly $1,600 for an iPhone. But as our complaint alleges, Apple has maintained monopoly power in the smartphone market not simply by staying ahead of the competition on the merits, but by violating federal antitrust law. Consumers should not have to pay higher prices because companies break the law. We allege that Apple has employed a strategy that relies on exclusionary, anti-competitive conduct that hurts both consumers and developers. For consumers, that has meant fewer choices, higher prices and fees, lower quality smartphones, apps, and accessories, and less innovation from Apple and its competitors. For developers, that has meant being forced to play by rules that insulate Apple from competition. And as outlined in our complaint, we allege that Apple has consolidated its monopoly power not by making its own products better, but by making other products worse. Apple carries out its exclusionary anti-competitive conduct in 2 principal ways. First, Apple imposes contractual restrictions and fees that limit the features and functionality that developers can offer iPhone users. Second, Apple selectively restricts access to the points of connection between third-party apps and the iPhone's operating system, degrading the functionality of non-Apple apps and accessories. As a result, for most of the past 15 years, Apple has collected a tax in the form of a 30% commission on the price of any app downloaded from the App Store, as well as on in-app purchases. Apple is able to command these fees from companies of all sizes. Apple has also suppressed the emergence of programs like cloud streaming apps, including gaming apps, as well as super apps that could reduce user dependence on Apple's own operating system and expensive hardware. And as any iPhone user who has ever seen a green text message or received a tiny, grainy video can attest, Apple's anti-competitive conduct also includes making it more difficult for iPhone users to message with users of non-Apple products. It does this by diminishing the functionality of its own messaging app and by diminishing the functionality of third-party messaging apps. By doing so, Apple knowingly and deliberately degrades quality, privacy, and security for its users. For example, if an iPhone user messages a non-iPhone user in Apple Messages, the text appears not only as a green bubble, but incorporates limited functionality. The conversation is not encrypted, videos are pixelated and grainy, and users cannot edit messages or see typing indicators. As a result, iPhone users perceive rival smartphones as being lower quality because the experience of messaging friends and family who do not own iPhones is worse, even though Apple is the one responsible for breaking cross-platform messaging. And it does so intentionally. For example, in 2013, a senior executive at Apple explained that supporting cross-platform messaging in Apple Messages, quote, would simply serve to remove an obstacle to iPhone families giving their kids Android phones, close quote. In 2022, Apple's CEO was asked whether Apple would fix iPhone to Android messaging. The questioner added, quote, not to make it personal, but I can't send my mom certain videos, close quote. Apple's CEO responded, buy your mom an iPhone. In addition to selectively controlling app distribution and creation, we allege that Apple is violating the law by conditionally restricting developers' access to the interface, which is needed to make an app functional on the Apple operating system. For a product like a smartwatch or a digital wallet to be useful to an iPhone user, it must be able to communicate with the iPhone's operating system. But Apple creates barriers that make it extremely difficult and expensive for both users and developers to venture outside the Apple ecosystem. When it comes to smartwatches, Apple not only drives users to purchase an Apple Watch, which is only compatible with an iPhone, it also uses its technical and contractual controls to make it harder for someone with an iPhone to use a non-Apple smartwatch. And when it comes to digital wallets, Apple's exclusionary conduct goes a step further. Digital wallets allow users to store and use passes and credentials in a single app, including credit cards, personal identification, movie tickets, and car keys. Apple Wallet is Apple's proprietary digital wallet on the iPhone. Apple actively encourages banks, merchants, and other parties to participate in Apple Wallet, but it simultaneously exerts its monopoly power to block these same partners from developing alternative payment products and services for iPhone users. For example, Apple has blocked third-party developers from creating competing digital wallets on the iPhone that use what is known as tap-to-pay functionality. That is the function that makes a digital wallet, well, a wallet. Instead, Apple forces those who want to use the wallet function to share personal information with Apple, even if they would prefer to share that information solely with their bank, medical provider, or other trusted third party. When an iPhone user puts a credit or debit card in an Apple Wallet, Apple inserts itself into the process that would otherwise occur directly between the user and the card issuer. This introduces an additional potential point of failure for the privacy and security of Apple users. And that is just one way in which Apple is willing to make the iPhone less secure and less private in order to maintain its monopoly power. The Supreme Court defines monopoly power as, quote, the power to control prices or exclude competition. As set out in our complaint, Apple has that power in the smartphone market. Now, having monopoly power does not itself violate the antitrust laws, but it does when a firm acquires or maintains monopoly power, not because it has a superior product or superior business acumen, but by engaging in exclusionary conduct. As set out in our complaint, Apple has maintained its power not because of its superiority, because of its unlawful exclusionary behavior. Monopolies like Apple's threaten the free and fair markets upon which our economy is based. They stifle innovation. They hurt producers and workers, and they increase costs for consumers. If left unchallenged, Apple will only continue to strengthen its smartphone monopoly. But there's a law for that. The Justice Department will vigorously enforce antitrust law. Enforcing the law protects consumers from higher prices and fewer choices. That is the Justice Department's legal obligation. That is what the American people expect. That is what they deserve. I am grateful to the attorneys and staff of the Department's Antitrust Division for their tireless work on this case on behalf of the American people. I'll now turn the podium over to the Deputy Attorney General.
Thank you very much, Mr. Attorney General, and good morning, everyone. In our fight against corporate misconduct, the Department's approach is straightforward and relentless. We identify the most serious wrongdoers, whether individuals or companies, and then we focus our full energy and devote all necessary resources to holding them accountable. Accountability promotes fairness, it drives deterrence, and it advances the rule of law. By holding all companies to the same standards, our approach to corporate enforcement benefits all Americans. Americans who deserve and who demand a justice system that holds accountable those who break the law. For over a century, our federal antitrust laws have been a critical tool for protecting competition, the competition that fuels and drives our nation's economy. These laws protect consumer choice in the market, they keep prices in check, they promote quality, and they open doors to innovation. Today, the department alleges that Apple, one of the world's largest tech companies.
And if you're just joining us, we've been listening in as Attorney General Merrick Garland unveiled a landmark antitrust suit against Apple filed by the DOJ today. The long-anticipated legal action comes after years of allegations that the tech giant holds a monopoly over the smartphone market. Let's bring in CBS News legal contributor Jessica Levinson to talk about it. So, Jessica, your impressions.
My impression, exactly as you said, this is a long time coming. The Department of Justice and other state attorneys general have been looking at Apple and their practices. One of the things that Merrick Garland mentioned at the very end that I think is so important for people to understand as we follow the suit is that this is not about Apple having a great product. This is not about iPhones being terrific or iWatches being fantastic. This is not about the wallet. It's about having a great product and then trying to push everybody else out in a way that hurts consumers, in a way that hurts competition, in a way that hurts innovation. And that's what I heard Merrick Garland really focusing on, because he wants to make sure we all understand it's not about being successful in business. You don't get a lawsuit from the Department of Justice just because you did a great job with a great product. You are on the receiving end of an anti-monopoly lawsuit if you're trying to push other people out to the detriment of, again, consumers and competition.
Okay, so here's what I don't understand completely, and I'm sure you can explain it to me. You know, the criticism for Apple, it sounds like pretty wide-ranging, right? Everything from the App Store, which I totally get. I totally get how limiting the App Store is, and there have been lawsuits about, you know, the companies, gaming companies being able to sell their products off of the app. Right, that you're right. Obligated to do this all this commerce on the app, in the App Store. So I get that, but you know the green bubble, blue bubble thing that he started off with, which I know is kind of like something that people always sort of chuckle and complain about. So my question to you is, if you create a tech product and you have specific software, particularly if you're first out of the gate, like Apple was with the smartphone, they were the first ones, are you obligated to create software that plays nice with your competitors? Because that's what he kind of seems to be suggesting to me.
That is such a good question. And I think you're going to see Apple respond to that, which is the government can't put an affirmative duty on me to say, why don't I make it easier for my competitors? And I think, and I know this sounds slight, but I think what the Department of Justice will say is, we're not creating an affirmative duty. You don't have to say, here's the bridge. You just can't say we're locking the door. And I know that sounds like we're just kind of splitting hairs here, but what the Department of Justice will do is say, it's not that you had to allow other apps, for instance. It's not that you had to allow other competitors. It's that you're functioning in a way that actively prevents other competitors from having a bigger space in the marketplace. And that is something where, and I think to your question, the Department of Justice is going to have to do a really good job of explaining why this doesn't just mean that every really successful tech giant suddenly has to open the doors and say, how can we help you competitors? That it's instead about saying, how can we make sure that we don't box you out, artificially keep a market share? And I think what you notice Merrick Garland saying is, do things that make it worse for consumers, like threaten their privacy. He talked about Apple Wallet. And he also talked about sharing medical information. Do things that are worse for consumers, but good for you, Apple.
So we did get a statement here from Apple, Jessica. Let me just read it here for our viewers. At Apple, this is the quote: "We innovate every day to make technology people love, designing products that work seamlessly together protect people's privacy and security, and create a magical experience for our users. This lawsuit threatens who we are and the principles that set Apple products apart in a fiercely competitive market. If successful, would hinder our ability to create the kind of technology people expect from Apple, where hardware, software, and services intersect. It would also set a dangerous precedent, empowering government to take a heavy hand in designing people's technology. We believe this lawsuit is wrong on the facts and the law, and we will vigorously defend against it. So, I mean, how is this different than back in the old days, the technology that existed for videotapes, which was you had your VHS system and then you had your Betamax system. The government said, hey, you can let the consumer decide. Ultimately, the consumers picked VHS, and Betamax went out of business.
Even though it was
allegedly it was the better quality.
Yeah.
We have AC/DC. I mean, we can't even use like the same kind of outlets when we travel all over. Countries can't even decide how electrical outlets work. I mean, so why is Apple being forced to do something that they say would be detrimental not only to the company but more importantly to the end user?
Well, I think they may not be. So let's be clear that this complaint may not be successful. And your question, again, it's such a good point, which is we allow the market to say we're going to push competitors out. We allow the market to say that it's going to be VHS who wins. And we don't want the government artificially propping up competitors. I think what the Department of Justice would say is, this isn't us artificially propping up Android. It's us creating a place where there's a fair playing field, where you can have that type of competition. And I'm not at this moment thinking of what's the good analogy between the VHS technology and the iPhone technology, where it's not which do you want to use, but it's iPhone kind of specifically trying to protect their technology in a way that is harmful to the users and harmful to competition. Now, one thing I want to point out from Apple's statement is both sides here are going to say, we have the better argument when it comes to competition. Both sides are going to say, we have the better argument when it comes to what's better for the end user. And both sides are going to say, we have the better argument when it comes to innovation. And these antitrust suits, and going all the way back to the founding of the Sherman Antitrust Act and why this is, I teach a case about sugar manufacturers and why you don't want to just have one sugar manufacturer in the country. It's all about making sure that we don't have to pay $20 for a gram of sugar. It's making sure that there is, think about airline tickets and making sure that no airline has a monopoly. So, but their questions, I think, point out that this is going to be a really complicated case for the Department of Justice to win.
I just want to point out that Apple stock has taken a little bit of a hit. It's down 3%. We'll see where that goes by the end of the day. But I want to go back to sort of the concept of antitrust and sort of, you must have to thread a needle because you do not want to inhibit innovation. And that's kind of what Apple is saying, right? They took a tremendous risk. We never had smartphones before the iPhone emerged, right? And then everyone else got to sit back and see how it worked out and then create a phone that, filled the void. And so,
and as Jessica points out, this society, like it or not, is a capitalist one, and it's all about pushing the competition out. It's about letting the consumer decide what they want and letting the chips fall where they may. They're not suggesting that Amazon go out of business because they've run out every small mom and pop bookstore, regardless of how I personally feel. I love mom and pop bookstores, but Amazon is the dominant bookseller in the world right now.
Right.
The government isn't saying, hey, you need to create a market space that allows mom and pop bookstores to flourish.
And it would seem to me that and we pulled away from the press briefing, so I don't know all the complaints that the government has, right? But the couple of things that they highlighted, they seem to me to fall into different categories. Like the idea that app creators are having a hard time and they're obligated to operate under Apple's rules is one thing. Now, when I upload my financial information into my Apple wallet, I do not expect Apple to be intervening. To me, I think of it, it's just a platform. Now, if I want to use the Apple Card, the Apple services, that's different. If I just want to store my information on here, I'm not expecting Apple to be, taking data from me. So to me, that seems like two different complaints.
I think what you're pointing out is that there was a lot in these complaints. It wasn't just there's a problem with the App Store. It wasn't just there's a problem with iMessage. It wasn't just there's a problem with the Apple Watches. It was also, and there's problems with privacy. And so part of bringing a big case is that what you want the judge who's going to rule on a motion to dismiss, because Apple is going to bring a motion to dismiss, is to see that Apple is taking all of these, that we have to see this as a cohesive whole, and that Apple is taking all of these actions and you put them together, and it really is creating a violation of our anti-monopoly laws, our Antitrust Act. And for Apple, they're going to say, I think in part what you've pointed out, which is these are different allegations. Let's take each in turn and look at each separately. And that's something that we see generally where the Department of Justice or plaintiff says, look at all the bad things that happened here. And the defense will say, all of these seem like slightly different allegations. Look at them each in isolation. Is that alone enough? But part of this, I think, is a litigation strategy where the Department of Justice has been looking into Apple and various activities that are not all the same for years and said, this is part of a cohesive whole. We're bringing this suit. And yes, it's a variety of different things that Apple does that we think are problematic.
So,
go ahead. Yeah.
I could not help but to notice that fighting for the consumer and the little man is kind of part of President Biden's push with campaign, right?
Yeah.
He did a whole thing on shrinkflation, right? He's done a whole thing
Student
on
loans.
these junk fees, right? Like this is kind of his jam, sort of. So does the timing seem interesting to you?
You're talking about politics.
So what I will say is the Department of Justice is supposed to be independent, and they're not supposed to make these types of timing decisions based on where we are in the election cycle. I have no information about what caused today, the second day of spring before an election year to be the day that the Department of Justice files this particular case. But it's uncontroversial that your point of Biden came in and there have been more antitrust suits. This is not a blip. And so I do think it's important for people to know this isn't the first. It likely won't be the last. It's maybe one of the only ones that merits you and I having this conversation live because it's Apple and it's such a big deal. But this was part of its platform. And we are seeing, just in terms of what I teach and what I'm asked about, I'm having to brush up on the antitrust information that I thought about a lot more, frankly, years and years ago, as opposed to now, because now it's a bigger deal.
But would the government bring a case that so in your mind, Jessica, before we wrap this up, it's like not very cut and dried. I think we've been trying, Emery and I, to say, well, no, it must be this, and it's clear that it's that. But they wouldn't bring a case like this if they didn't think that there was a chance that they could win, right? They wouldn't waste everybody's time. Or would they? I don't know.
Not only that, it would violate their ethical duties. You can't bring the case if you think that it's frivolous. And the Department of Justice is subject to the same types of ethical duties. So it wouldn't just be egg on your face. It wouldn't just be a waste of time. You can't weaponize the Department of Justice for political ends. We should remember this regardless of who is the person who appoints the attorney general. So they have to believe that they can win this, not just for embarrassment, but again, because we've seen, for instance, in the wake of the 2020 election, when attorneys file lawsuits and there's no chance of winning, they can face repercussions for that.
All right. I think the press briefing continues. But Jessica, that was really, really good. I know I'm much smarter now as usual because
we always
of Jessica.
are. Every time we have Jessica talking with us. Jessica, we thank you as always. Appreciate it.
Thank you.
And just to recap our breaking news, Attorney General Merrick Garland has unveiled a landmark antitrust suit against Apple filed by the DOJ today. The long-anticipated legal action comes after years of allegations that the tech giant holds a monopoly over the smartphone market. Apple says it believes the lawsuit is wrong on the facts and the law and will vigorously defend against it. We're going to have much more coverage of this throughout the day. But next, we're going to head to Times Square and CBS Mornings.
Mr. President, there's a lot to talk about.
A lot to talk about.
If China invades Taiwan, what will the U.S. Navy do?
Here in Tel Aviv, second siren in about 10 minutes.
This Humvee just pulled up and said,